Thank you everyone so much for coming and joining this session that we have this afternoon. I hope you all enjoyed your lunch. I'm Nafisa Chaudhary, and I have my co-panelists here today, my colleagues Arjun Gandhi and Genevieve Canton? Yes. All right. Well, we have a very interesting topic today. We've got a smaller crowd than the other side, but I'm hoping that if you guys have any questions at all during this presentation, do feel free to raise your hand and ask the questions, and we can make this interactive and make it into a discussion, because this is a topic that many employers don't really think about too much or too long and hard until it becomes a problem. And then when it becomes a problem, I can tell you from my own practice, when these issues arise, they can really be a big thorn in the side of a business if you've got unfair competition that you're dealing with. So it's always good to keep in mind the important principles of law and certain things that you can put into place in advance to protect your business. And really what we're going to speak about today is putting those things in place from a practical perspective, keeping in mind the legal principles so that you can all take those steps on behalf of your respective companies. So we're going to go through a little bit of a quick agenda. We've broken our presentation today into three sort of major headings. The first is the legal principles. So I'll be speaking a little bit about general concepts of law, starting at a very high level, sort of at the 10,000-foot level. What sorts of legal concepts exist? What should we all be worried about? What should we be thinking about when we are setting up our protections that we're going to be putting in place to protect our business? And then after that, we're going to move on to a legal update and talk about some interesting cases. And Arjun's going to take us through some recent decisions. This is an area of law that's always evolving, and it's ripe with discussion, certainly from the courts. And every case is context specific, but we can take principles and derive a basis for how we set up our decisions based on the cases that are coming out of the courts. So hopefully you'll find some of those cases interesting. And then finally, we will round out our discussion with Genevieve, who will be talking about some practical tips, given the legal principles and the updates to the cases. And then we'll have some time at the end for Q&A, so if you've got questions at the end, please do take that opportunity as well. So we'll start first with the legal principles. Now, the sources of the law, there are a few different sources of where the law comes up. And the reason why I included this slide is let me start a little bit about my practice. So I'm an employment lawyer. I do a lot of breach of restrictive covenant work, a lot of unfair competition work. So when these cases come up, what happens typically is they're usually an emergency of some form, an urgent email, an urgent communication from a client who will say, so-and-so, who was our top salesperson or our vice president, has left the company. They've gone over to a competitor, or they've started a competing business, and they are now going after our business, and they know everything about our business. So we're really worried, what are we going to do? The first question that I ask is, what are their contractual obligations, right? So we talk about the contractual duties. So one of the sources of law is contract, right? What does the employment agreement say, or any other agreement that governs the employment relationship? And then I will also ask questions about the nature of the employee's duties. So what did that employee do when they were employed? What types of information did they have access to? What was their decision-making authority? How closely did they work with clients? And the reason I ask about that is because I'm interested in knowing and trying to form for myself an opinion as to whether this employee could be characterized as a fiduciary. Now, fiduciary is a legal term. It comes, when we talk about fiduciary duties, which many of you will have heard and no doubt it comes up from time to time, fiduciaries are a certain level of employees who are very high level. There's a lot of trust that's put in these employees. They are often the face or one of the faces of a business. And they have certain duties that attach to them being fiduciaries, which don't necessarily arise from contractual law. So even if an employee has no contractual restrictions, right, if the contract says nothing about non-competition or non-solicitation, if they are a fiduciary level employee, you might still be able to restrain them from engaging in unfair competition. So first is contract. Second source of law is equity fiduciary duties, which is found in the law of equity. And then finally, there is the law of tort, which is a third source of law. And these are things like breach of confidence, conversion, intrusion upon seclusion, which is a relatively newish one that the Court of Appeal in Ontario established a number of years ago. Knowingly assisting in a breach of fiduciary duty is another tort. And torts are typically a source of law that's made by judges, right? So over decades and decades of the common law, which the courts made through jurisprudence, they come up with certain concepts. The courts have come up with concepts which are causes of action, and they've set out that certain types of conduct is unlawful in the civil context, and like negligence and breach of confidence and these kinds of things. So the third source of law is tort, all right? So just we'll keep that in mind because that's going to provide a high-level structure for the rest of my presentation. So we'll start first with the contractual duties, all right? This is, remember, the first source of contract of a person's duties or potential source of a person's duties when they leave an employer and start a competing business or go to a competitor. And the reason why, again, this is important is because when we're talking about contractual obligations, one question that I often get from clients, right, is so-and-so left my business, they're now starting a competing shop, but we don't have any, we have a contractual non-compete. His employment contract clearly says that he can't compete, and yet he's competing, right? So we then look at the contractual duty itself, and we start thinking about, is it enforceable? From a contractual perspective, can that employee be restrained? And so from a contractual perspective, what is a covenant? We talk about, you'll hear this term restrictive covenants, comes up a lot, and that comes from the contractual law, right? A covenant is described by, or defined by Black's Law Dictionary as a formal agreement or promise, usually in a contract or deed, to do or not do a particular act. Now, there's various types of contractual restrictive covenants that you'll see in contracts, employment agreements typically, and these are set out here. Non-competition clauses is one, non-solicitation clauses is another, confidentiality clauses, you'll often see, or it's common to see intellectual property clauses and non-disparagement clauses. So let's start with non-competition clauses. So at the outset, and Arjun will speak a little bit more about this point, so I won't spend too much time on it, and you'll hear this, if you attended the statutory updates presentation, you would have heard this as well, no doubt, that there's been a very recent update to the law in this area, which is last year, the Ontario government introduced a new law that said that non-competition clauses, generally speaking, are no longer permitted in Ontario. There are some narrow exceptions which Arjun will speak to, but basically, if you are now trying to enforce or introduce a non-competition provision into a contract with a new employee that you're hiring today, who's not a C-suite level employee, then you'll find that's likely unenforceable. However, for contracts that were entered into prior to October 25th, 2021, the non-competition provisions that are in those contracts might still be enforceable. So you need to be conscientious still about non-competition clauses to an extent. Now, notwithstanding any statutory changes in the law, we should also be mindful of the fact that the courts historically have always had an abhorrence for non-competition clauses. And the reason being, there's a public policy rationale. The courts have consistently held that, look, we're a free market economy, right? We encourage competition. We encourage that society, everyone benefits when we've got free competition. So who are we, the courts, to come in and stop people from competing? And beyond that, there's also been arguments that, an individual has a right to go and earn their livelihood. So if they're going to, shop, they've left shop or they've been terminated from one shop and they go to another shop to earn their livelihood, who are we, the courts, to stop them from earning a livelihood? So their initial position when you look at contractual provisions is always, I don't really want to enforce this. That being said, I also hear from clients often, I represent both defendants and plaintiffs. So the plaintiff is obviously the employer who's lost an employee who's now competing. and the defendant is the one who's brought in an employee from a competitive shop, and the former employer is serving our client with demand letters saying, hey, you're not allowed to be doing this or that. And from the perspective of the employer who's now brought in a new employee, I often hear from clients who say, well, they've got a non-compete provision, but that's not enforceable. Non-competes are never enforced. And the answer to that is, certainly many times non-competition provisions are not enforced, but sometimes they are enforced. So we can't really make those blanket statements either. Now, if there is no written non-competition clause, a court will typically not restrict a departing employee's right to compete with a former employer, except in very limited circumstances, which is those circumstances being with respect to fiduciaries, which I referred to earlier, and I'll return to the concept of fiduciary. But if an employee is not a fiduciary and they have no restrictive covenant, meaning nothing in their contract that says that they can't compete, then that person typically is free to go and join a competitor and start working. The problems arise is when that person takes confidential information, or if that person is a fiduciary, or if that person is misusing in some way their former employer's confidential or proprietary information. So just on this concept that the courts typically don't impose non-competition obligations if there's no contractual requirement, I've set out a few cases here, the first being sheet metal versus Landry, which is a New Brunswick Court of Appeal decision. And it just basically sets out sort of the court's rationale. And there's another decision from 2008, the Supreme Court of Canada, and RBC versus Merrill Lynch. These cases, some of these older cases, particularly the Merrill Lynch case, and there's another one, Elsley, that we'll talk about. These are some of the foundational cases when you talk about restrictive covenants. There's this area of law has raised so many questions that it's one that has gone up to the Supreme Court of Canada on a number of occasions. So these decisions, if you're ever looking for sources of the law and for a good discussion on what the courts do and not do, these cases are good ones to return to. The Elsley case, which I just referred to a moment ago, is a decision from 1978 of the Supreme Court of Canada. And that case sort of set out what the courts look for when they're talking about non-competition clauses and what they would think is, what they would consider to be enforceable versus non-enforceable, right? And we know, obviously, that you can have a contract that says any number of things, but if the contract is contrary to public policy or if it's in breach of a statutory requirement, the courts will strike it down and say it's not enforceable. And in this case, when it comes to non-competition clauses, as we said, often the courts are looking for public policy reasons not to enforce them, but there are cases where the courts will enforce them. And so when will a court enforce them? What is considered reasonable? The courts in this Elsley decision said that, in particular, there are three things that courts look for. Number one, the clause has to protect a legitimate proprietary interest, all right? So ultimately, the purpose of all of these clauses, and non-competition in particular, is to protect property, right? We understand as a society, again, going to public policy, that we all benefit when private property is protected. So if the clause is legitimately trying to protect a proprietary interest, there's a greater likelihood of it being enforced. If, however, the non-competition clause is looking to protect something that arguably the employer has no proprietary interest in, the courts will be less sympathetic. The second thing that the courts will look at is whether it's appropriately limited in terms of time and space. So time, what does that mean? It means when you look at these non-competition clauses, often it says that you agree that you won't compete for a period of, let's say, 12 months, during your employment, as well as for a period of 12 months post-departure, or a period of 5 years post-departure, or a period of 3 years post-departure. The time limitations is something that routinely non-competition provisions are struck down on the basis that they're way too long, that they overreach, that a 5-year non-compete in these circumstances make no sense because you don't need that long in order to protect your business. So each case, of course, is determined on its facts, but from a temporal perspective, you often want to pay close attention to other cases where, it was a similar type business, similar type circumstances, and let's say a 12-month non-compete time period was upheld, you could then have an argument to say that 12 months is appropriate in my case. 5 years you often see in the context of a sale of a business, right? So there's two types of contexts where non-competition clauses arise. One is an employer-employee relationship, right? So you act for a company, you're hiring a new employee. That employee has no ownership interest in the company. They're just coming in straight as an employee, and you have a non-competition provision in the contract. That's one context. Another context is where you've got a sale of a business, right? So one company is buying another company. In the context of that sale of a business, the CEO of that company is now going to become an employee of the purchaser. And as part of the sale, you have a restrictive covenant, a non-competition clause that says this CEO, when they join our company, he or she agrees that when they leave, they're not going to compete for a period of, let's say, 5 years. The courts have distinguished that in the context of a sale of a business, the longer time periods are more justified because of the equities of bargaining power. You've got typically two sophisticated commercial parties, plus the departing CEO or high-level employee has a lot of information and knowledge about and property of the company. Plus, they've received usually a significant sum of money as a result of the sale. So the courts are more inclined to enforce those provisions that arise in that context rather than in a strict employer-employee relationship. So that's appropriate limited in time, and then there has to be appropriate limitations in space. What does that mean? That refers to the geographic scope of the non-competition provision. So the courts expect that the non-compete clause will say that so-and-so can't compete for a period of X number of months or years, and that time frame is reasonable, and they won't compete within a certain geographic location, right? Within Canada, within Ontario, within 5 kilometers radius of our head office. So when drafting these provisions, you have to be mindful of what's reasonable in terms of a geographic scope, right? Employers obviously would like to say they can't compete anywhere in the world, right? That's the easiest thing to say, nowhere, ever, anytime. But a court would look at that and say, well, if you're operating only in Ontario, why would it bother you if they're competing in Japan, right? Like so yeah, the courts will definitely strike down clauses that they see as being unreasonable. And then it has to be limited in nature, in terms of the nature of activities prohibited. Again, there's a tendency to overreach with these contracts, these provisions. People want to just have these blanket, they can never compete everywhere at any time. But the courts have said, look, people are entitled to earn their livelihoods. I'm allowed to go next door and work at a pizza shop if I'm, was selling chicken on this day, right? Like, why is it bothering anyone? And so you do have to think about the nature of the activities that are prohibited, and it should be sufficiently clear to the person departing as to what activities they're not allowed to engage in. And the duty of establishing whether a covenant is reasonable lies on the party seeking to enforce it, and then the employer can, if they can establish that, then the onus shifts back to the other side. So I'm just going to fly through some of these slides here. I've sort of touched on these concepts. And this one I'll stop here briefly, that every case is, Elsley really stands for this principle that every case needs to be determined on its own facts. So, a one-size-fits-all approach, which we're all tempted to do because of the efficiencies of it, may not be the right approach, because ultimately it'll come down to a contextual analysis. Another type of common restrictive covenant from a contractual perspective is non-solicitation clauses. And these are the provisions which say that you, employee, agree not to be solicit, or when you leave, you agree not to solicit any of our employees or our clients. And these provisions tend to be more favorably received by the courts, and they're easier to enforce. But that being said, you still have to be mindful about drafting, and you still have to be mindful of the temporal scope, right? You can't just say you can never solicit forever. Courts won't hold that up, and you can't say there's differences of opinion about on the geographic scope, but there are some cases that say it should be geographically limited as well. And the fiduciary level of employees may have different responsibilities, even in the absence of a contractual restrictive covenant. So the analysis is very similar between non-competition, non-solicitation agreements in terms of enforceability, but oftentimes they're, like I said, the non-solicits are a little bit easier to enforce. The courts are a little bit more sympathetic to employers who are complaining that their former employees are soliciting their clients, for example, because the courts hold that yes, an employer has, or a business has, a proprietary interest in their relationships with their employees. So if you have someone who used to work for you now and is using those relationships to undercut your business, one can see how that might be unfair. But you have to pay attention to drafting, because one thing that I commonly see in non-solicitation agreements or covenants is an employer will say, you agree not to solicit or accept business from a client or a customer. And there are a number of cases where the courts hold that when you go one step further and say you can't even accept business from a former client, that's one step too far, right? That it's up to the client to decide who they want to go to. So if you don't solicit them and they come to you, then they should be allowed to do that. And if any part of the provision is unenforceable, typically the entire provision comes crashing down. Confidentiality clauses is something that you'll also see that comes up fairly often. It should set out, all the confidential information that you are looking to protect. And these ones, again, relating back to the proprietary interests of the company or the employer, these are easier to enforce because there is clearly a legitimate proprietary interest at the heart of what's you're seeking to protect. And then non-disparagement clauses are another type of restrictive covenant that we see that comes up. I see them more in the context of departing employees, right? So if you're entering into a settlement agreement, or you give someone a termination letter or a separation agreement, in exchange for a release, they agree that they're not going to be disparaging you. It comes up in that context, more so than in employment agreements at the outset of employment. And so at a very high level, ask yourself, when you're drafting your restrictive covenants, will the departing employee know what their responsibilities are under this agreement? If the answer is no, then you're at risk of having the contractual provision struck down. Very briefly, fiduciary duties. Who is a fiduciary, and why is it important? Fiduciaries have an enhanced duty of good faith and fidelity towards a former employer. Right? So this means that even after a fiduciary level employee leaves an employer, they still have a duty of good faith, and to an extent a duty of loyalty to their former employer. And this means that while they can compete, they cannot compete unfairly. Right? So usually it's a very senior executive level employee, and there's an extensive and continuously developing body of case law on who is a fiduciary versus who is not a fiduciary. And you'll see cases all over the place on this one, so it's a little hard to predict. But if you've got a salesperson, for example, who's left, you might be able to establish that even though this person isn't a executive, they still, had fiduciary level duties. You just never know, so you got to be flexible and know that this area is inherently risky. And it can be, though, very dangerous, fiduciary duties. If you have an employee who's a fiduciary level employee, for example, who's departed, or you're bringing in a fiduciary level employee from another company and you're hiring them new, and this person comes in and the former employer establishes that this person has engaged in a breach of fiduciary duties, and your business has benefited, there could be significant consequences if a court finds that indeed there was a breach of fiduciary duty. Gas Tops is one of the leading cases in that area, and there, 4 departing employees had left, and they set up a competing shop, and they took contracts that the former employer said, these belong to us, and ultimately they were forced to pay almost $20 million when all was said and done. So this is, again, equitable law can be powerful, so be mindful of that, and you don't need a contractual restrictive covenant in order for an equitable duty to be upheld, right? So even if there's no non-compete provision per se in a contract, if someone is a fiduciary and they're unfairly competing, the court can still intervene and stop them from doing what they're doing. And then finally, we've got common law causes of action like breach of confidence, conversion, intrusion upon seclusion, the ones that are listed here. These are other areas where you can rely on if you feel your business is facing unfair competition, right? You can sue for, let's say, a breach of confidence. What is a breach of confidence? It's that, oh, someone has taken my confidential information and they're using it inappropriately. So there could be a contractual duty to not use confidential information, but even in the absence of a contractual duty, you can rely on the common law, which says that people can't take your confidential information and misuse it. And that's rooted actually in the tort of conversion. Conversion is this tort which says, you know, I've taken someone else's property and I've converted it into my own. You can't do that. It's kind of like a theft. So all of these things, different types of things you can rely on, judge-made law, in order to protect your business as well. But this is sort of your third level of protection. Judge-made law is a little bit more open to interpretation. So if you have a contractual duty on top of the judge-made laws or the torts that you can rely on, then you've got that double-barreled protection. And if you've got equitable duties on top of that, then it's a third level of protection. So there's just a few points here. When you get the slides, you'll get this information, but I'm going to hand it over in the interest of time to Arjun. Thank you.
Thank you so much, Nafisa, for providing a very comprehensive overview of the law of restrictive covenants. I'm now going to be providing a legal update and speaking to some interesting cases that have popped up in the last 2 years. So thank you for your attention. Nafisa already went through this. I'll just be brief. The law of non-competition provisions was already difficult to enforce before the new legislation came into effect this last year. Only in exceptional cases would the nature of an employment relationship justify a non-competition agreement at common law. And then on October 25th, 2021, the Ontario government introduced the Working for Workers Act, and royal assent to that bill was given on December 2nd, 2021. So that's when it came into effect. This legislation amended the Employment Standards Act to prohibit non-compete agreements between employers and employees, subject to two narrow exceptions, which I will get to shortly. Before we move on, I wanted to just highlight the definition of non-compete agreement that's used in the legislation. You can see the definition up there, but I just want to actually point out the underlined part where this legislation essentially prohibited any agreement between an employer and an employee that prohibits the employee from engaging in any business, work, occupation, profession, project, or other activity that is in competition with the employer's business after the employment relationship ends. The reason I've highlighted that I've underlined that part is to show how broad it is. This applies quite broadly, and they're really trying to make sure that this legislation applies to any sort of non-compete agreement. Although the legislation has prohibited non-compete provisions largely, there are some things that haven't changed. Namely, employers may still prohibit employees from soliciting their employees and clients. And second, employers may still prohibit employees from disclosing their confidential information to third parties. So non-solicit provisions and confidentiality clauses are still allowed. And now let's speak to the two exceptions. These exceptions largely stem from the common law, but I'll explain them a little bit deeper. The first exception to this ban on non-compete provisions is where there's a sale of a business and the seller becomes an employee of the purchaser. And the second exception is where the employee is a C-suite executive. Now, when I say C-suite executive, I mean a CEO, a CIO, CTO, CFO, COO, president, et cetera. And we've actually received a number of questions recently where an employer says, can I create a non-compete agreement with an employee who is in title only chief technology officer or something like that? They don't really have the responsibilities of a C-suite executive, but they have that title. And while there hasn't been much case law on that recently, it is our strong belief that the courts would see through that and would hope that this exception only applies where the employee is a true C-suite executive. So now I'm going to move on to some of the case law. This is one that recently came out this year in Ontario, Perec v. Schechter. The case law that I'll be providing will illuminate some of the changes that have happened. So in this case, the plaintiff purchased a dental practice. As a side note, in the morning session, Christine mentioned that a lot of our employment cases involve dental practices, so I don't know what's going on there, but you'll see that as a recurring pattern. But anyways, the plaintiff purchased a dental practice in 2020 and maintained the employment of several employees. The defendant employee previously executed a non-competition agreement with the employer prior to the transfer in ownership. And in October 2021, the defendant left the clinic to engage in a new practice that breached the non-competition agreement. What the Ontario court decided in this case was that the new statutory ban on non-competition agreements would not apply. And the reason for that is that the prohibition on non-competition agreements entered into force on October 25th, 2021. With this non-competition agreement being signed prior to that, the statute did not apply. In this case, in fact, the non-competition provision was enforceable because it only applied for 2 years and was limited to a 5-kilometer radius. So the takeaway from this case is most notably that the new legislative prohibition does not retroactively affect contractual arrangements in place before October 2021. The next case is M&P Drug Mart, Inc. v. Norton. This is a 2021 Ontario case. In 2014, a pharmacist agreed to a non-competition clause with the pharmacy he worked at. And in 2020, the pharmacist resigned from his employment and went to work at a pharmacy less than 3 kilometers away. The Ontario court found here that, first of all, the new legislation did not apply. The agreement was signed in 2014, so the new legislation did not apply, and the common law of reasonable notice would apply. But if you'll see here in the text, that's the non-competition provision. The court found that at common law, this was unenforceable for being overly broad and ambiguous. See the underlined part. This provision prevented the employee from carrying on, being engaged in, being concerned with, being interested in, directly or indirectly, any undertaking involving any business the same as, similar to, or competitive with the business within a 15-kilometer radius of the pharmacy. As we can see, this is extremely broad, especially with language such as being concerned with, interested in, even indirectly. And so that is why the court found this to be unenforceable. In this case, the employer had the onus of showing that the clear meaning of the non-compete provision was a demonstrably reasonable restriction of activity, and the employer failed in proving that. The provision tried to prohibit this defendant from holding a non-pharmacy related position with an employer who had some pharmacy related aspects to their business. And the takeaway from this is that the enforceability of restrictive covenants at common law is still determined on a case-by-case basis, and it is essential to ensure that a provision is drafted clearly and no more broadly than is necessary. Something that's come up quite a bit, and we've received a lot of questions about, is whether, with this new ban on non-competition provisions, can employers apply an agreement with an employee that doesn't prohibit competition, but rather disincentivizes it? So there's limited case law on this topic, but it is interesting what there is. So what we've seen is a 2014 British Columbia case. It was decided by the BC Court of Appeal. The case is Raybergen v. Creston Veterinary Clinic. And in this case, a non-compete provision in a veterinarian's employment agreement stated that she was required to pay her employer between $90,000 and $150,000 if within 3 years of the end of her employment, she set up a practice within a 25-mile radius of her employer's clinic. The amount would depend on when the practice was exactly set up, and it was calculated based on the cost of investing and hiring an associate and the impact on the employer's goodwill. The trial judge decided at first that this was a restraint on trade and it was unreasonable. But almost surprisingly, the Court of Appeal decided that this was a restraint of trade, but it was reasonable. The appeal was allowed, and the Court of Appeal held that the clause, which is not prohibitory, but permissive, doesn't penalize the employee for competing, but rather compensates the former employer for costs incurred from, among other things, training the departed employee. So our stance on this is that there's still not much case law on the topic. We don't know exactly how an Ontario court would apply this kind of situation. And the Court of Appeal did mention that the decision it made was very much based on the context and the facts at hand. So it's our recommendation that if an employer is attempting to create disincentives to competition in lieu of a prohibition, employers will need to try narrow, reasonable, and clear and justifiable clauses. So now I'm going to provide some cases about non-solicitation provisions. This one is PureFax Financial Solutions, Inc. and Chung. The facts of this case are such that employees of a company signed an employment agreement with a non-solicitation provision. After resigning, the former employees were approached by a client of the company to respond to an RFP. The employees responded and used information about the company in their proposal. The court decided here that the simple act of responding to an RFP did not breach the employment agreement. This is especially so because it was the client who had reached out to the former employees. Furthermore, by using the hourly rate, an hourly rate that they knew was lower than the former company's rate, and by incorporating very limited material from other work of the company that they were involved in, the employees' actions in this case did not fall into a breach of confidence. So the takeaway from this case is that non-solicitation agreements may not protect against situations in which the former employees are contacted by clients. And after resignation, employees are entitled to use some limited information about their former company. Another non-solicitation case is Point One Graphics, Inc. v. Ruskowski. In this case, after being employed by the plaintiff for 17 years as a sales employee, the defendant was now working with a competitor company. The Ontario court here decided that it would not read in or imply a restrictive covenant into the employment contract where the parties had bargained for one and then allowed that restrictive covenant to lapse. Here, there did not exist an enforceable contractual restrictive covenant on which the plaintiff could rely to establish its entitlement to an injunction. As a result, the plaintiff was not entitled to injunctive relief here. And the last topic that I'll be covering is breach of confidence, and I'll be speaking to two cases that have recently come up. This first one is Man Engineering Limited and Desai. In this case, an employee worked for a competitor during the course of his employment. Shortly before his departure from the employment, the employee forwarded to himself company contracts, proposals, and passwords. The court thankfully decided here that documents that the employee had sent to himself constituted confidential information, and that the employee sent them to his personal email account with the intention of potentially using and disclosing them to competitors in the future. In this case, the employee was found to have breached his contractual obligation to safeguard confidential information, and the employee had also breached his common law duties of loyalty, fidelity, and good faith when he worked for a competitor in the course of his employment. As the employer did not suffer any losses here, the nominal damages of only $1 were ordered by the court. So the takeaway from this case is that an employee holds contractual obligations to safeguard confidential information and implied duties of loyalty, fidelity, and good faith to their employer. As well, if an employer's rights are breached, an employer typically has to prove damages in order to get something more than a nominal sum. And the final case I'll be speaking about is Canadian National Railway Company and Homes. This is a 2022 Ontario case. In this case, an employee had the authority to hire contractors. And on behalf of the company, he hired several companies that he, turns out, owned, and he approved invoices in their favor. Of course, the employee concealed his involvement and ownership interest in these hired companies. The court deemed this to be a breach of confidence, and the court ordered disgorgement of the profits that the employee had earned from the company. This decision clarifies the use of the disgorgement remedy in cases involving fiduciaries, and it shows that the court or the disgorgement remedy may be granted even where the ill-gotten profits are no longer in the wrongdoer's hands. And now I'm going to pass it off to Genevieve to provide some practical tips and takeaways.
Thank you very much, Arjun. Excuse me. So now that we've taken you through the contractual and common law principles and some of the interesting updates in the case law, I now have the pleasure of going over some practical tips and takeaways from today's session. So, no matter what leads to the termination of employment, whether it be, a for-cause termination, a without-cause termination, or a resignation, some employees leave on bad terms. That's just a fact. Or sometimes they might leave with ambitions, right, of starting maybe their own shop. So really the point of this session today is to chat about, how can businesses better protect themselves from employees leaving and taking their intellectual assets, trade secrets, and goodwill. So first and foremost, if we're looking to restrict an employee's post-employment obligations, an obvious way to do so is to ensure that you have enforceable restrictive covenants drafted into your employment contracts. But as you've heard here today already, the law of restrictive covenants is constantly evolving. So it's very important to have your employment contracts reviewed regularly to ensure that they're still compliant. Because if they're not, then unfortunately you're out of luck. So when we're talking about drafting provisions, it's very important to avoid generic language, as we've gone over already. Agreement should be very much tailored specifically to the employer, the nature of the business, the size and scope of the employer, and in particular, the particular employee's responsibilities. One size, unfortunately, does not fit all when it comes to these provisions. So if we have a sales employee, for example, they would often have access to, you've got your customer list, your pricing list. So that's the type of information that you would want to include in that particular employee's agreement, but maybe not in another employee's agreement, depending on the nature of the employer. So when we talk about confidentiality and protection of trade secrets in this slide here, I'm really talking about the contractual the agreement here. So when we're talking about drafting these provisions into a contract, there's really two themes that you want to make sure that you're addressing in your contracts. One is defining, again, the business. So what's the business's confidential information? That might be trade secrets. It could be formulas, recipes, and the whole list that's listed up there. It could be customer lists, pricing lists, so on and so forth. The second piece is, you want to clarify that, the employee is prevented or barred from using, for any reason other than as authorized by the employer, or disclosing outside of the company any information belonging to the company. And there's usually what we'll see in employment contracts, whether we're drafting it or it might come across our desk from another firm or another employer, is with respect to the what is authorized use, or what does that really mean? And usually there's several examples or provisions in the employment agreement that will speak to that directly. One is, an employee might be able to disclose that information in the event that it's necessary to do so. For example, by law. So during the course of a court decision, the employee would have the ability to talk about, let's say, confidential information. Apart from that, an employee certainly would be able to disclose confidential information, when they're in the course of performing their duties as the employee. And the other, the other exception would be, when the employee is expressly authorized to do so by the employer, and usually that might be written consent, for example. Lastly, and very importantly, the agreement should identify that the restrictions are not time limited. So, it's not going to be a one-year restriction. It's just open restriction. So really, the employee would have to keep that information confidential forever. That would be different than a common law example where, there may be a time limit on that if you're a fiduciary or something along those lines. So when it comes to non-solicitation provisions, as you've heard already, in the absence of a binding non-solicitation provision, a departing employee can, unfortunately, try and poach employees and customers. So what we've found is, normally a clearly drafted non-solicitation covenant preventing the poaching of employees is generally enforceable. So it's pretty easy to get that type of provision right when you're drafting your non-solicitation provision. But what's more difficult to get right is the non-solicitation that prevents the solicitation of customers or clients. Oftentimes, what we find are very broad provisions, and what we want to do is limit those provisions. And part of the challenge is that employers have to demonstrate that the restriction is reasonable. And when it's drafted broadly, it's very difficult to do that. So what I've got up next on the slide is a really good case example that I think really hammers home this point. So this is a very recent decision from the Ontario Superior Court. Once again, it's another dental practice employer, shockingly. So this is Nicholas versus Dr. Adita Witulska Dentistry Professional Corporation. And the facts of this case are this. So Miss Nicholas was a 28-year employee. She was at all times a part-time dental hygienist at this dental practice. 20-some years into her employment relationship, her employer presented her with an employment contract for the very first time. Prior to that, she just didn't have a written employment contract. And in that contract were several restrictive covenants, including a non-competition agreement, a non-solicitation agreement, confidentiality, non-disparagement, all the fun things. And this employee, throughout her entire experience with this employer, or her entire work with this employer, worked at their Brantford location, but the employer always had two locations, Brantford and Cambridge. So long story short, this employee ends up resigning from her employment, and she ends up joining another dental practice about 3 kilometers away. And she ultimately ends up suing for constructive dismissal, and in response, the employer counterclaims against the employee for breach of contract, and asks the court for an injunctive relief to stop this employee from continuing to compete and to soliciting the patients from her former practice. So the provision here that's at issue is in front of you on the screen here. And I won't read it, but if I invite you all to take a quick look at it. And I've highlighted really what's important here. So it's in A, so 8A, so solicit business from any patient of the employer if such business is of the same general character as that of the employer during such a period. So what the court found was that the employer failed to prove that the particular non-solicitation provision was reasonable as between the parties. And again, the big issue the court took was with the term patient and the term any. And essentially here, according to the court, the big issue here was the limitation that was placed on the term patient. And what the court said was that on the face of this term, it really includes any patient at either location, so whether it be the Brantford location that she actually worked at or the Cambridge location which she had never worked at. And it applied to her regardless of whether the plaintiff herself treated a patient at either location, and regardless of whether or not the patient was actually a patient at the time the employee was employed there. So long story short, way too broad. Court didn't like it, they struck it out, and unfortunately they were unsuccessful in their counterclaim. So moving on to non-disparagement provisions. As you've heard earlier from Navisa, so these are less common in an employment contract, but I am seeing more and more of them. They're more common in a release agreement as opposed to an employment contract, but I'm seeing more in an employment contract context. And much like non-solicitation provisions and non-competition provisions, they must be reasonable in scope. What I've done here is really break down pros and cons of these provisions in employment contracts. And the reason for doing so is because sometimes it might just make sense not to include it at all in the employment contract. So the pro is obviously that it might disincentivize a disgruntled employee from talking poorly about the company after their employment ends or during the course of their employment. But the con is that they're very difficult to actually police and enforce. So unless you have someone at your workplace dedicated to searching social media feeds to see what this employee has said poorly about the employer, it's difficult to actually find the information and then subsequently enforce it. So if this type of provision is important to you, then certainly include it in the context of the employment agreement. But if you do have concerns, and again, the concern would be about the scope and whether it's actually enforceable or not, it's better just to leave it out and include it in a release. So what if you don't have an enforceable termination provision at this point? Or sorry, not termination provision, a restrictive covenant in your employment contract. Is it too late to add it in? The quick answer is no. So if you don't have an enforceable restrictive covenant in your employment contracts, but you want to add one at this juncture, our response is that you can do that. But to be safe, you must ensure that you provide some consideration to the employee in exchange for that new contractual term. Without providing that new consideration, effectively, the new agreement is of no force and effect. We see that in the same way that if you're presenting a new employment contract to an employee and you don't provide consideration, you wind up with that same issue. So consideration in this case might be a salary increase, it might be a one-time bonus, it could be a promotion, but the message that we want to put out there is it's not impossible to, at this juncture, take that step to implement these provisions and do so to ensure that they're enforceable. Okay, so this is more about how to ensure compliance with the provisions that you currently have, in your contract following a termination. And I think on termination, this is really an easy way to hopefully enforce or prevent the employee from not complying with the provisions in their employment contract. But when you're considering whether to pay an employee a lump sum versus a salary continuance, I think it makes good sense to consider a lump sum option if there is some concern that this employee might be doing something bad after their job ends. But it is easier to control an employee's adherence when the hand that's feeding them is still feeding them, right? So if they're receiving a lump sum, there's really no incentive for them to be good after they've separated from their employment. But with the salary continuance, the employer's still hanging over their head and certainly will be watching. In terms of after termination, there are several remedies that may be available to you. You may have a basis to demand repayment for monies over and above Employment Standards Act entitlements. You may have a basis for injunctive relief, and that would be to ask the court to restrain a former employee from soliciting customers or employees. And you may be able to get a portion, and I want to underline a portion here, of your legal fees reimbursed for having to take those steps to enforce the restrictive covenants. Okay, so aside from what we've just gone over, there are actually a lot of other practical steps that employers can take to try and ensure compliance with the restrictive covenants. And I have a nice juicy list here, but I'll go through them because I have a few points to add. But the first, and I think it's a pretty obvious and a pretty good one, is supplying employees with company-owned devices and requiring that all business be conducted on these devices. If you're allowing your employee to work from home with their personal computer, it's inevitable that confidential information is going to wind up on their home computer. We don't know what they're doing with that home computer or what they're taking off of that home computer. So that's one good way. Separate and apart from that, and relatedly, it's good to have a policy in place on electronic monitoring of employees. And by the way, as I'm sure all of you know, you're now required in Ontario to have these electronic monitoring policies. And if you haven't put them in place yet, please contact us and we can help you do that. But with that electronic monitoring policy in place, you can take steps to monitor what your employees are doing. And if anything looks unusual, you can take steps to find out what's actually going on and investigate what the employee is doing. And suspicious activity might be, for example, downloading information from one computer and sending it in an email to a personal email. So there's lots of ways that you can try and figure out what your employees are doing and take the appropriate steps if you have to.
And just on that, sorry to interject. So the reason why policies are so important is because one of the things that a party who's seeking to resist the enforcement of a confidentiality obligation is that I have privacy rights, right? That the employer looking through the computer, even if it's a company-owned device, is a breach of my privacy because I had a privacy interest in, in certain things that I did on the computer. And the privacy area of law is also a very evolving area. If you have a clearly worded policy in place that puts all the employees on notice that these devices are being monitored for business purposes, then that takes away an employee's right to complain after the fact or to rely on a privacy-related defense And it really gives you as an employer a leg up. And this came up in one of our cases a number of years ago. We had an employee, a very senior person, two actually, who left and joined a competing shop. And after they left, the gentleman turned in his computer, and the entire computer had been wiped clean of all data. So that was the first big red flag. Where'd the data go? And he gave some sort of explanation or excuse, which sounded very suspicious to us. So we sent it off to a forensic specialist, an expert, and they brought all the data. They were able to recover a lot of the data. And what they found was that this fellow and another fellow who had also left and joined a competitor had, for months, been starting to work with the competitor and been talking about setting up a competing business and talking about, confidential stuff they shouldn't have been talking about. And so we brought an injunction motion right away to restrain them. And remember, the other side said, well, you can't win an injunction motion. No, nobody, the courts never enforce these things. We were successful. The court did enforce it. And one of the things that the other side also argued is that you looked into our client's, private information, and that was a breach of an intrusion upon seclusion. And luckily, in our case, we had a policy, or it was written right into the contract that the employer will be monitoring electronic systems. And so we said, well, he can't complain about that. It's written right there in the contract, and the judge agreed. So in that case, we were successful, and having these things written and put in place in advance really proved to be very helpful.
That's an excellent point. So I'll jump on to the next one then. So, an easy thing that you can do in the event of a termination is highlight the restrictive covenants and, set them out in your termination letter so the employee knows exactly what they should and should not be doing in the event of a termination. If we've got an employee who's a fiduciary, it's equally as important to, in addition to highlighting the restrictive covenants that they may or may not have in their employment contract, indicate in the termination letter that, you are fiduciary, and as a result of that, you owe additional obligations to us in the, today and in the future as well, right? So following the termination of your employment. Another thing to consider is making a forensic copy of a departing employee's hard drive. And this is important for several reasons. It might be onerous to do it in the event of every single termination, but it really does give you a picture of what the employee has done to date, to the date of their termination. And if anything is improper, then you as the employer can take steps to recover that information. But what's really important to remember is if you do take that step, you want to ensure that you're making that forensic image prior to reassigning the computer to another employee, which commonly happens. If you don't do that, then you unfortunately have all this data and you won't be able to distinguish between which employee did what. So if that is a step that you want to take, make sure that you do that prior to reassigning the device. And lastly, there's a whole host of things we could have listed here, but if you are concerned about an employee's post-departure conduct, you can easily send them a letter, and I would also copy the letter or send it directly to the employee's new employer, reminding them of their obligations. So you're not to solicit our customers and clients, you're not to compete with us, but clearly you're already competing. But that really just puts all the parties on alert. And if it does become necessary to take that next step, you can write a cease and desist letter. And then at that stage, if you're going to be writing the cease and desist letter, you want to be able to act quickly and bring the injunction to the extent that that's the step that you end up taking. Okay. And in terms of court action, so if it does become necessary due to a breach of a departing employee's obligations, then you may have a cause of action against the departing employee at common law as well as under contract. But, just to highlight importantly here, in addition to potentially having a cause of action against the new employee, you may also have a cause of action against the new employer for, several of the torts that Nafisa went through earlier on. So, knowing assistance of a breach of fiduciary duties, conversion, all of those helpful common law torts that exist. Okay, so that takes us to questions.
I just jump in there and say that's why you see the employment agreement document, the confirmation that says, I agree, I don't have possession of the former employer's
Yeah.
contact information, and
That's a really good point, and for the benefit of the video recording, what was Christine just made the comment that oftentimes you'll see in an employment agreement when you're hiring a new employee, particularly a senior person who's coming from a competitor, that it says right in the employment agreement that the employee has to sign off stating that I agree that I'm not bringing any information or confidential information from any other third party or from any former employer. And that way, that gives the new employer a modicum of protection if later on the former employer says, hey, you've been stealing our confidential information, for the new employer to say, no, in fact, we made it abundantly clear to the new employee that was coming in that they were not to bring any confidential information, and the employee confirmed that they hadn't. So therefore, that gives you a defense there, and it's actually a very good thing to include in a contract, particularly for the more senior employees that you're bringing in. And just at a high level, one comment that if we have a little bit of time, this morning one of the things that came up in this first presentation of the day on updates to employment law and constructive dismissal and contracts was this feeling. I don't know how many of you attended that ultimately there's so much discretion when it comes to a court. When you look at like who's a fiduciary, what's confidential information, what's reasonable, what's a proper geographic scope, what's a proper temporal scope. Everything comes down to the context and the facts, and how is anyone supposed to tell up from down and be able to make any decisions as to, whether they're engaging in bad behavior or whether they're at risk of having, disgorging $20 million worth of, profits or what have you. My experience in this area, and it's very similar to a discussion that came up this morning, is that ultimately judges are humans, and that they do have wide discretion in this area. And the case for, other cases which are similar in facts can give us some basis to rely upon when we go to court and we make our pitches. But it's also important to tell the story in such a way that wins the heart of the decision maker, because I find that if a judge is sympathetic to your case, then they will find a way. There is enough in the law of contract and contractual interpretation principles and in equitable laws like fiduciary duties and in torts for the court to craft something that will give you some protection if they feel that your business is being undermined by someone. By the same token, if they're not sympathetic to you, if you come in having done some things which are questionable, not you obviously, but in the company, the judge is not going to be sympathetic and going to find a reason not to grant the relief. Go ahead. Yeah, so the question, just for the benefit of the recording, is have we seen any cases where there is someone who's not a C-suite person, but the courts have restricted them from competing? They don't have the title, but they're a very senior person. And the short answer is yes. So on this, two things. There's a new law which just came into effect in October of 2021, which says that in order for a contractual non-compete to apply or to be enforceable, it has to be applicable to a C-suite person. So that's the contractual duty. But there is the whole idea of fiduciary duty, right? So what does that mean? If you've got an employee who's a very senior person and they have like the president duties or executive duties or vice president duties, or they're the face of your company to the public, but they have no contractual duties whatsoever, so they have no non-compete obligation anywhere in their contract. Will the court still restrain that person from competing? The answer is they might if the competition is unfair, right? So there's no duty you can't restrain someone who's a fiduciary level employee from competing full stop, but you can restrain them from unfairly competing. And the unfair competition arises where that departing senior employee, number one, you can establish that they are a fiduciary. So there's a legal test for that, and there's lots of discretion to the courts. But sometimes it's pretty clear that someone's a fiduciary employee. And you have to show that they're doing things unfairly, like taking your confidential information and building their business on the back, or their springboarding is another one. Springboarding is, where someone knows the secret sauce, for example, or the secret ingredient to your soft drink, and they've taken that information and now they're jumping ahead into the market, even though they're a new entrant, because they've taken this confidential information. In those cases, the courts will intervene if the conditions are right to restrain it, even if there's no contractual duty to not compete. And I can give you an example. There was a case I was working on where we had a senior person who had been with the company for over 30 years. And she was in many ways the face of the company, right? Because the owner was, kind of off doing his own thing, and she was there who was the leading person, and she was the one who was in touch with all the vendors, all the clients, everyone. And then at a certain point, there was a new owner that came in, and it was pretty clear that this new owner was not going to be able to work with this senior employee, right, that had been there for 30 years. Now, the 30-year employee didn't have any contractual duties to not compete. Now, her contract was very, like, one of those one-page contracts that have, like, I will work for the company, and very, very few details. So that employee said, okay, well, no, I don't have anything that's stopping me from competing. And so she started another business, but she didn't disclose it, first of all, to us, to our client. In fact, we took the position right away when she was terminated that you're a fiduciary and you have ongoing fiduciary duties. We're going to continue to pay you by way of salary continuance, as Genevieve suggested. So during this period, we are expecting that you're not going to be competing with us, and you're a fiduciary, by the way, so you can't use any of these relationships that you've built with our clients against us. And she said, well, I'm abiding. And then, of course, a few months later, we discover quite by happenstance that she's incorporated another business and has been setting up a competing shop. And so we were able to commence legal proceedings right away on the basis of fiduciary duties, even though there was no contractual duty in that case.
I had a case where that we terminated a fellow, and he said, well, I heard this was happening. And so that caught their attention. And so after the meeting ended, they went and looked at the camera and saw that the day before, he was carrying out boxes of documents in his car. And checked the computer. And he stayed up to like 3 o'clock in the morning transferring all sorts of secret information. So we, of course, the next day retracted and didn't ask for required time. And he's suing us.
Yeah.
That takes some stuff. And we didn't resolve it, and I think our client would be unhappy if we tried to settle it, so somebody tried to say, maybe he's got counsel and we'll pay it back, but the owner got caught.
Oh, yeah, because he got caught, exactly.
Yeah.
Exactly.
And so it's important to have, but that's a pure breach of,
Mm.
it's not really a restrictive covenant, but it goes to the point, you can, when somebody acts unfairly, you certainly have ways of helping
Yeah.
pay the commission.
Yeah, and it's important also to move quickly, especially when it's taking of confidential information, because the longer you sort of sit on your hands or not do anything, the courts will say, well, if it was so confidential, why did you allow this thing to linger for so long, right? So the importance is being timely. Hopefully it doesn't happen to any of your businesses, but if I was a betting person in my practice tells me anything, it does come up. So it's always best to be on guard and to look out for these things and to think about them in advance. Oh, and I think we are out of time. So thank you, everyone, so much. And we really hope that you enjoy the rest of the day.